Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 59th and 60th lecture series. So we have gathered here to discuss about a leading case which is prescribed for the Advocate on Record examination. Why should we read a leading case? To become a leading lawyer. So once you know the law, once you accumulate knowledge and experience, that knowledge and experience, that learning will give you earning. So therefore, let us understand what is this leading case is all about, and which case we are going to discuss is serial number 83 in the revised leading case subject, State of Punjab versus Davinder Singh. This is the case which we are going to discuss about. It is our regular practice that we recite preamble of the Constitution of India by having strong faith and belief that it is our goal and it is our soul. The essence of the Constitution is reflected in the preamble. So it is a conscious reminder to ourselves that our journey is too far and we need to achieve each and every day, each and every moment. Still, people are below poverty. Still, children are starving in the street. We did not possess or we do not have 100% literacy. Discrimination is there. Caste system is there. Discrimination on basis of many aspects are still prevailing. Though our founding fathers have said about the preamble, this is what our goal is. So it is everyone's duty. It is whose duty? To make the India prosper, to make the nation healthy. Indian should be healthy, then India will become healthy. I should, or we should, each one of us should prosper, then India will prosper. That is most important. Because our mother India is a group of Indians. Right? Collectively, Indians become India. So once you change yourself for the betterment, you are going to see the better India. That is why we generally say, have your heart, make your start, and don't hesitate to play your part. Your part is very important. So with this, I will recite the preamble of the Constitution, dear friends. And I request each one of you to recite the preamble with a commitment and sentiment, and that is our identity and that is our unity. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Now let us focus on this leading case, State of Punjab versus Davinder Singh. This was delivered in detail and recorded in video number 57 and 58. But still, let me give you the brief background of the case. Therefore, becomes easy for you to follow. State of Punjab. the name itself indicates it's an appeal by the state of Punjab versus Davinder Singh. What is the issue about? Before that, let us see the facts of the case. The facts of the case is, state of Punjab has enacted a law. The name of the law, please note down, dear friends. Punjab Scheduled Caste and Backward Classes Reservation in Services Act 2006. I repeat, Punjab Scheduled Caste and Backward Classes Reservation in Services Act 2006, in short, Punjab Act. In this, there is a particular provision, Section 4, Subsection 5. Section 4, Subsection 5, that is the provision which has given 50% of the vacancies of the scheduled caste reservation shall be offered on first preference to Balmikis and Mazhabi Sikhs amongst the SCs. So what does it say, dear friends? Article 341 clause 1. Please remember, Article 341 clause 1 empowers the President of India to notify which subcaste will fall under the scheduled caste. So that is the power of the President of India. Article 341 clause 2 empowers the Parliament to include any subcaste under SC category or exclude any subcaste from SC category, scheduled caste category. So that is the constitutional provisions with respect to the power of the President and power of the Parliament is. Now the state of Punjab has enacted this provision by giving 50% preferences to the subcaste under the scheduled caste itself. That was challenged before the Punjab and Haryana High Court. Why it was challenged? Reason is, when they are giving 50% preference to Balmikis, other subcastes are denied the opportunity. So why should we get denied the opportunity? So therefore they have challenged it. And the Honorable High Court of Punjab and Haryana has held that it is unconstitutional. You cannot subclassify within the classification. Already scheduled caste is a classification, and you cannot subclassify by saying that I will give preference, 50% preference to Balmikis. So that is unconstitutional. How the Punjab and Haryana High Court has come to this conclusion? Reason is, there was already a constitution bench judgment pronounced by the Supreme Court of India. That is E.V. Chinnaya case. E.V. Chinnaya case. So that case was relied upon by the Punjab and Haryana High Court. So what was held in E.V. Chinnaya case? Subclassification is unconstitutional, because whatever the subcaste falls under the SC category, they are all homogeneous. They are all placed on the same pedestal. So you cannot give preference to one subcaste. You cannot give such preference. That is what the Constitution bench of this Honorable Supreme Court has held. So Supreme Court judgment binds on all the high courts. So Punjab and Haryana High Court has relied upon that judgment E.V. Chinnaya case and held the particular provision, Section 4, Subsection 5 of the Punjab Act as unconstitutional. Now Punjab state has enacted this law. Therefore, they are aggrieved. They want to uphold the constitutionality of what they have enacted. So they have preferred an appeal before the Honorable Supreme Court. So the matter came up before the 3-judge bench. 3-judge bench has referred the matter to the 5-judge bench. And the 5-judges bench has referred the matter to the 7-judges bench, because they are going to question or check the correctness of the 5-judges bench judgment, that is E.V. Chinnaya. Therefore, the matter came up before 7-judges bench. So what is the issue here now? This is the background of the case. Issue is, whether there can be a subclassification within the classification. That means whether Valmiki's and Masabi's Sikh community, that's a subclassification within the classification of scheduled caste, is it constitutionally permissible? So that was the issue before the Honorable Supreme Court. And whether E.V. Chinnaya case, which has held that subclassification is impermissible, whether does it hold a right law, does it lay down a correct law or not? So that is the test. So these are the issues, dear friends, raised before the Honorable Supreme Court. Now the findings, the decision is 6 judges majority and 1 judge has given a dissenting judgment. So majority has held that subclassification is permissible. It was authored by Honorable Justice Dr. D.Y. Chandrachud, the then Chief Justice of India. He has authored this judgment on his behalf and on behalf of Honorable Justice Manoj Mishra ji. The other judges, remaining judges, though they have agreed with the Honorable Chief Justice of India, they have given their separate views by giving their own opinion, but concurring with the Chief Justice of India that subclassification is permissible. So dissenting judgment given by Honorable Justice Bella M. Trivedi. Her ladyship has given a dissenting judgment by holding that Chinnaya, the law laid down by Chinnaya, E.V. Chinnaya judgment is correct. That is the correct law. Therefore, subclassification is impermissible. That is what according to her ladyship. So on the last occasion, we have discussed about the judgment delivered by the Chief Justice of India. Now what we are going to study today along with everyone is majority opinion given by the separate views expressed by the honorable judges. So we will be starting with Honorable Justice Gavai, Honorable Justice B.R. Gavai, who is the present Chief Justice of India. What my Lord has said. Let us see the discussion, dear friends. See, this is the judgment which I am going to rely upon. It got reported in, please note down the citation, 2025, Volume 1 SEC, Volume 1 Supreme Court Cases, page number 1. I repeat, 2025, Volume 1 Supreme Court Cases, page number 1. So in this judgment, I am going to take you to page number 270, dear friends. This is a separate views expressed by Honorable Justice B.R. Gavai, concurring with the Chief Justice of India. I am reading the conclusion part, dear friends. I therefore hold that E.V. Chinnaya, which held that subclassification amongst the scheduled caste for the purpose of giving more beneficial treatment to a group in the larger group of the scheduled caste is not permissible, does not lay down a good law. That means what they are saying is the honorable judge is holding that E.V. Chinnaya judgment is laid down an incorrect law, meaning thereby E.V. Chinnaya case got overruled. Subclassification is permissible. On what basis the honorable judge comes to this conclusion? Already the reservation is given to scheduled caste. That itself a classification. Open category, other backward clauses, then SC, then ST. This itself a classification. Why do you want to further classify? Because all those subcastes will fall under the SC category. Why do they require any subclassification? The answer is whatever the subcost mentioned under the scheduled cost, they do not constitute homogeneous clause. They are not equally placed. They are heterogeneous. Their degree of sufferings are different. How do they come to this conclusion? Reason is, in the government jobs, their representation, Valmiki's representation is very less. Though they come under SC category, some of the subcasts are duly represented, but these subcasts are not duly represented. So they have empirical data that these subcasts are denied their opportunity to get employment in the government jobs. So how to bring those socially, economically backward classes? Those are deprived classes. So we need to bring them into the mainstream. Therefore, let us give 50% reservation. Preferences. So based on yardstick, by taking proper empirical data on their appointment, on their service. So therefore, E.V. Chinnaya, what the law laid down by E.V. Chinnaya is incorrect. This is what the finding of our Honorable Chief Justice, Honorable Justice B.R. Gavai. My Lord has said further, the second point number 2, it's paragraph 520.2, that subclassification among us the scheduled cost for giving more beneficial treatment is permissible in law. So it is not something that we are discriminating on the basis of subcost. Beneficial legislation should go to the deserving people. So that is permissible. Because in the majority, authored by Dr. D.Y. Chandrachud, my Lord has said, by giving special preferences to Valmikis, this is also a facet of equality. Now, before us, Valmikis are deprived of, therefore they are unequals. So let us give their preference to the government job. Therefore, a person who is sitting at the last bench, he will also come forward and he will also sit along with the first benchers. So therefore, this is the right to equality. Subclassification is a facet of equality. So there is no discrimination as such. Because Article 15 Clause 4 provides for reservation. Article 16 Clause 4 provides for reservation. Though general clause says no discrimination, but there can be a special preference given to socially, educational backward classes as well as SC, ST. So we are protected under the law. Punjab Act is protected under Article 15 Clause 4 and Article 16 Clause 4 of the Constitution of India. 520.3 paragraph, that for doing so, the state will have to justify that the group for which more beneficial treatment is provided is inadequately represented as compared to the other cost in the said list. See, when this particular section 4 subsection 5 was challenged, why it was challenged? Because it gives special preference, 50% preference to the Valmikis and Mazhabi Sikh communities. Why do they do so? Right? That is the question. The answer is, when there is inequality, when there is an inequality among those subcasts, then we can give preference. That is what Lordship has said. That while doing so, the state, it is a onus upon the state of Punjab, will have to justify the same on the basis of empirical data, that a subclause in whose favor such more beneficial treatment is provided is not adequately represented. So first thing what the state has to do, whether are they duly represented or not. If they are not duly represented, then we can give the preference. How do you say that they are not adequately represented? Because based on the data, empirical data. Next, point number 5, that however means we have to stop there. There is a note of caution. What is that note of caution? However, while providing for subclassification, the state would be entitled, the state would not be entitled to reserve 100% seats available for scheduled cost in favor of a subclause to the exclusion of other cost in the list. This is very important, dear friends. State of Punjab has come out with 50% preferences. Why not 100% preference? If it is 100% preference, that means it becomes unconstitutional. You are denying the entire opportunity to other subcosts under scheduled cost. So that is unconstitutional. So that is a note of caution. Though you can give preference to Valmikis, but still it cannot be 100%, it is only 50% reservation. So state cannot give exclusive 100% reservation to subcost. So that is an exception. Point number 6, that such a subclassification would be permissible only if there is a reservation for a subclause as well as the larger clause. So therefore, 50% preferences to Valmikis and other 50% will be available to all the subcost falls under the scheduled cost. Point number 7, that the finding of M. Nagaraj, these are leading cases, M. Nagaraj, Jarnail Singh and Davinder Singh, to the effect that creamy layer principle, dear friends, for AOR aspirants, this is very, very important. When you are expressing the views of Honorable Justice, my Lord B.R. Gavai, you have to note down the creamy layer principle, because they are interested, examiners are interested to know about what you know about the constitutional provisions, constitutional doctrines and the principles. They are not interested in the facts, they are interested in law. Therefore, we are noting, when you are writing this examination, you have to note down this principle of creamy layer. That the finding of M. Nagaraj, Jarnail Singh and Davinder Singh to the effect that creamy layer principle is also applicable to the scheduled caste and scheduled tribes lay down the correct position of law. So, when in the subcaste in SC community, when they have attained a good quality life, then they are considered to be a creamy layer. So therefore, creamy layer should not get the benefit of reservation. So creamy layer principle applies to SCs also, scheduled caste also. That is what they have held. That the criteria, so how do you say that he has become a creamy layer in the scheduled caste? What is the criteria? The criteria is that the criteria for exclusion of the creamy layer from the scheduled caste and scheduled tribes for the purpose of affirmative action could be different from the criteria as applicable to the other backward clauses. So what is the criteria for other backward clauses may not be applicable to scheduled caste. There can be a different criteria. So before I part with the judgment, I place on record my deep appreciation for the valuable assistance rendered by the learned counsel appearing for the parties. So in this case, the Honorable Justice B.R. Gavai, my Lord, has held that subclassification is permissible. And why do you subclassify? On the basis that there is no representation, not due representation in the government jobs. So how do you say that there is no due representation? It is based on empirical data. And then creamy layer principle is applied, and it is not, it is creamy layer principle applies to the scheduled caste also. So these are all the findings, and ultimately they have said, they have held subclassification is permissible. Right? Now coming to the another honorable judge, Honorable Justice Vikram Nath, my Lord, has held that I am generally in agreement with the reasons and conclusions arrived at in the opinion of Honorable the Chief Justice and Brother Gavai Justice, in particular that the holding in E.V. Chinnaya that subclassification within scheduled caste was impermissible does not lay down a good law. So subclassification is permissible and stands overruled. Chinnaya stands overruled. Further, any exercise involving subclassification by the state must be supported by empirical data. So the state comes out with a preference for a particular subcaste that has to be justified by empirical data. The next point is, I am also in agreement with the opinion of Brother Gavai Justice that the creamy layer principle, dear friends, don't forget this. Creamy layer principle is also applicable to scheduled caste and scheduled tribes, and the criteria for exclusion of creamy layer for the affirmative action could be different from the criteria as applicable to other backward classes. So His Lordship Vikram Nath Justice has completely agreed with Chief Justice of India Dr. D.Y. Chandrachud, my Lord also, as well as Honorable Justice B.R. Gavai also. Now coming to the another judge, Honorable Justice Pankaj Mittal, that is at page 290, dear friends. Page 291, there is a summary of His Lordship. The summary of Lordship is at page para 607, page 291. Agreeing with the scholarly separate opinions authored by the Chief Justice and Brother Gavai Justice, I summarize my views as under. This is the view expressed by Honorable Justice Pankaj Mittal. Point number 1, 607.1, paragraph. The policy of reservation as enshrined under the Constitution and by its various amendments requires a fresh relook and evolvement of other methods for helping and uplifting. So what is the reason for reservation? For helping and uplifting the depressed class or the downtrodden or the persons belong to SC, ST, OBC communities. So long no new method is evolved or adopted, the system of reservation as prevailing may continue to occupy the field with power to permit subclassification of a class, particularly scheduled caste, as I would not be suggesting dismantling of an existing building without erecting a new one in its place, which may prove to be more. Number 2, second point is, in the constitutional regime, there is no caste system and the country has moved into a casteless society except for the deeming provision under the Constitution for the limited purpose of affording reservation to the depressed class of persons, downtrodden or belonging to SC, ST, OBC. Therefore, any facility or privilege for the promotion of the above categories of person has to be on totally a different criteria other than the caste, maybe on economic or financial factors, status of living, vocation and the facilities available to each one of them based upon their place of living. Point number 3, the reservation, if any. See, dear friends, this is very important. How do you apply creamy layer principle? The criteria has been held here. The reservation, if any, has to be limited only for the first generation. Only for the first generation or one generation, and if any generation in the family has taken advantage of the reservation and have achieved higher status, the benefit of reservation would not be logically available to the second generation. So they are declared to be a creamy layer, therefore they are denied the opportunity of reservation. It is reiterated that periodical exercise has to be undertaken to exclude the class of persons who after taking advantage of reservation has come to march shoulder to shoulder with the general category. So they were deprived class, but after getting reservation, their first generation has become a top class. So therefore they do not require any reservation. They are competing with the other open category. So therefore, the second generation does not require any reservation. So the reference is accordingly answered, and it is held that subclassification of scheduled cost is permissible in law for the purposes of reservation. So though we are moving into from cost system to costless society, but as far as reservation is concerned, we are bringing the deprived class, marginalized class to the mainstream. Therefore, they can also compete, sit next to the open category, and they can march and they can have brotherhood. That is most important. Now, yet another judge has given a concurring opinion with his separate views. His Lordship, Honorable Justice Satish Chandra Sharma, Justice. My Lord has said, I have had the privilege of reading the lucid and detailed opinion authored by Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India, and Honorable Mr. B.R. Gavai, Justice, respectively. I am fully in agreement with both opinions to the extent that the validity of subclassification within scheduled cost has been held to be constitutionally permissible. Moreover, I am fully in agreement with the opinions to the extent that any exercise involving subclassification by the state must be supported by empirical data that ought to underscore the more disadvantaged status of the subgroup to which such preferential treatment is sought to be provided vis-a-vis the Constitution clause as a whole. However, on the question of applicability of the creamy layer principle to scheduled caste and scheduled tribes, I find myself in agreement with the view expressed by Honorable Justice Gavai, that is, for the full realization of substantive equality inter se the scheduled caste and the scheduled tribes, the identification of the creamy layer qua scheduled caste and scheduled tribe ought to become a constitutional imperative for the state. So his lordship has also in agreement with the majority, as well as the creamy layer principle not only applies to other backward classes but also applies to scheduled caste and scheduled tribes. So these are all the majority opinion expressed by the honorable judges. Ultimately, they have said, though subcaste falls under the scheduled caste, they are not duly represented. Their representation in the government jobs are very, very minimal. So therefore, we need to give 50% reservation, not 100%. If we say 100%, it becomes unconstitutional. Only 50% is sufficient. Once they avail the reservation, first generation has come to the good level, they are living a dignified life, then they cannot, the second generation cannot obtain the reservation. This is what the creamy layer principle is, dear friends. So ultimately, the majority view is that 6:1, the majority has held that subclassification within the scheduled caste is constitutionally permissible. So E.V. Chinnaya case, the correctness of E.V. Chinnaya is, they have held E.V. Chinnaya is overruled. E.V. Chinnaya did not permit the subclassification within the scheduled caste, therefore it did not lay down a correct law. So this is the conclusion of the majority view, dear friends. Thank you so much for your patience hearing.